Kia ora everyone, my name is Carolyn Young, Chief Executive at Retail NZ. Thank you so much for joining us today for this webinar session where we're going to talk with the team from the Ministry of Business, Innovation and Employment, otherwise known as MBIE, about the Consumer Guarantees Act. So we expect this session to last about 45 minutes. We'll cover the Consumer Guarantees Act and understanding what it is to do when things go wrong and what tools and information are available to help you decide the best course of action as a retailer. There will be an opportunity for questions on the way through and at the end. Do feel free to either raise your hand or put a question in the chat and we will get to you as soon as we can. We are recording the session so that you can watch it later and share it with your team or share it with anybody else that you're aware of too, because we think it will be a valuable tool for all retailers. So I'd also like to thank Lania for doing all of the administration and organising to make this all happen. So thanks very much, Lania. And also like to introduce to you Cate Bruce, who's the Quality Assurance Analyst at MBIE and Customer Service Centre, and Kadie Wilson, who's an advisor in the Consumer Protection team. Kia ora, Kadie and Cate. Thank you very much for joining us.
Thanks for having us.
Perfect. Well, we know there's a lot to cover, so I'll let you guys get on with it straight away and I'll come back in as questions come through.
Hello everyone, thanks for being here today. I'm Kadie, I'm an Outreach Advisor for Consumer Protection. In my role, I work on content for consumers on our website, our social medias and for campaigns.
Hi everyone, my name is Cate and I'm a Quality Assurance Analyst in the MBIE Customer Service Centre. So our advisors take calls on behalf of Consumer Protection and we speak to both consumers and businesses. It is my role to ensure that they are trained well, supported and are providing exceptional general guidance to our consumer protection callers.
Our role is to provide general guidance around consumer laws and the resolution process. We guide and empower, but we do not advocate, as the Consumer Guarantees Act is a self-enforcing act that's not regulated and it requires negotiation by both parties. Therefore, we don't deliver any determinations or provide personal advice, and it's up to the consumer and / all the business to use the resolution process.
So today we're going to go through some common problems to highlight how we like to answer common queries. We hope that going through these scenarios will provide a bit more clarity on how you as retailers can navigate these situations too. The way we like to approach these common queries is to first ensure we have a good understanding of the situation. We'll then refer to our toolkit resources and we'll then look at what the resolution options could be depending on the situation. So our goal is to equip you with tools to use if things ever go wrong. These steps can hopefully avoid any customers complaining to others, either on social media or in person, and prevent any legal escalations. However, as you'll see throughout the webinar, legal escalations through courts or tribunals is sometimes inevitable, and it can actually be really helpful. These legal avenues can offer a final determination of a situation when the two parties are unable to agree on a resolution amongst themselves. This webinar will also aim to help you make sure your customers get what they pay for and, if needed, a repair, refund or replacement for a faulty product or service. Any customer complaint should be dealt with as quickly as possible, whether that's through providing a remedy when the Consumer Guarantees Act applies or simply pointing customers to the website guidance we have that shows when the Consumer Guarantees Act does and doesn't apply.
To completely understand the scenario, we can use skills such as using clarifying questions to connect what laws could be in play, active listening, understanding the Consumer Guarantees Act and characteristics of other consumer laws to connect whether they're in play, and identifying key elements. It's about finding out the most information you can by listening and by asking targeted questions to determine whether the CGA applies. From there, you can locate the resources which shed light on what your obligations could be.
The Consumer Guarantees Act set the standard for when consumers buy a product or service, and this means that if these guarantees are not met, the consumer is entitled to a remedy. We do have more detailed information about the guarantees on our website. However, the common guarantees you'll likely encounter are acceptable quality, so this means that products must be fit for their normal purposes, acceptable in finish and appearance, free from minor defects, safe and durable. Another common guarantee is the fit for a particular purpose guarantee, which can include specifications that either the consumer asked for or the business told the consumer that the product was suitable for. Match the description is another common guarantee, which ensures the products consumers receive must be the same as the description in a catalogue, online, on packaging and labels, or any sample or demonstration model shown by the business. The last common guarantee that you may come across is the guarantee that products must arrive on time and in good condition.
There are also consumer guarantees that apply to services. Here are some definitions for the common ones you're more likely to come across. Carried out with reasonable care and skill generally means that any work done must be at least as good as the work of a competent person with average skills and experience for that type of work. Fit for a particular purpose the consumer told the seller about means that when a consumer has told the service provider what work the consumer wants them to do and the service provider accepts the job, that they must make sure the consumer gets what they want. And carried out within a reasonable time frame if no time was agreed means that if the consumer and the service provider haven't agreed on a time to finish a job, the provider must do so within a reasonable time.
So as the guarantees set the standard for when consumers buy a product or service, if these guarantees are not met, the consumer would be entitled to a remedy. The first step in determining what the remedy should be is to assess whether the fault or other issue is minor or serious. If the problem with a product is minor and it can be fixed, the business would have three choices: repair it free of charge, replace it with an identical product at no extra cost, or give it a full refund. For a minor issue, the customer must accept the remedy chosen by the business. It is recommended that businesses think carefully before offering repairs. If these are likely to be expensive or labour intensive, perhaps it could be better to offer a replacement or a full refund instead. It's also important to note that refunds must be in cash or credited back to the customer's credit card. A business cannot offer a store credit or an exchange note.
A problem or fault with a product or service is considered serious if a reasonable customer who knows the nature and extent of the fault would not buy the product or service beforehand, if the product or service is significantly different to its description, sample, or demonstration model, the product or service is unfit for its normal purpose and can't easily be made fit for purpose within a reasonable time. For example, washable wallpaper that bubbles after being wiped clean. It's unsafe, for example, a bicycle with faulty brakes, or if the business refuses, fails, or takes too long to address the problem. In these circumstances, the customer has a choice to either ask for their money back, ask for a replacement, or they can take it elsewhere to be fixed and claim repair costs back from the business. Even if a business thinks that they can repair a serious fault, the customer can still choose to get their money back instead. And if the customer chooses a repair, the business should make sure that the customer knows it's a serious fault before repair work begins. If the business doesn't make this clear and the fault can't be fixed, the courts have decided that the customer can then reject the product or service, and then the business will have to give them a refund or replacement as well as having tried to repair it. Does anyone have any questions so far? We have time for 2 quick questions now.
One of the things I was going to say is that one of the things that comes through our advice line, because we've got an advice line for our members, and so members often ring us with inquiries, they'll often find when something is not quite right and a customer comes back, they often try and demand, a full refund. And the real challenge, I think, for the retailer is how they have that conversation about, well, actually, there's 3 options. We can repair it, replace it, or refund. And, how do you determine who has the right to say, well, we're going to repair it or replace it or give you a refund? Because actually there's 3 options there. Can the retailer just say, well, actually, we're going to repair this free of charge for you?
If it's a minor fault, which is defined by if it can be fixed easily within a reasonable length of time, then that means that the business has the choice of which remedy they want to give a customer. So if the customer asks for a refund in that circumstance, then the business can, offer a replacement instead or offer their choice. But when the fault is serious, which means that it can't be fixed easily or it can't be fixed easily within a reasonable length of time, then the customer can ask for their choice of remedy. So it all depends on whether the fault, whether the problem is minor or serious.
And so the challenge then is working out where it is in the spectrum from a consumer perspective and a retailer perspective, right? So for all the retailers out there really thinking about, is it a minor, and how do you describe it to the consumer so they understand it's a minor fault, or is it actually more into the serious way? And in order to keep the customer happy, if you're sliding down to the end where it's a serious fault, really thinking about what a replacement or a similar type value would be, or having it compensated to the value. That would be accurate.
Yeah, we have some tools coming up as well that can help navigate those conversations.
Yeah.
So I think, yeah, we can come back to this as well as we get a bit further on. It's all about those kind of conversations that both parties can have amongst themselves. And then ultimately, if it can't be sorted, then a determination can be sought.
Excellent. I don't see any hands up with any further questions. So maybe if we move on to the toolkit, we'll just have a quick look through all of the participants just to check there's no hands up.
Yeah, that sounds good. So yeah, now that we've gone over those guarantees and fault categories, it's quite important to note that these guarantees won't always apply to every situation. So on the screen, we've got some key questions that can be asked to gather a better picture of the situation and a business's obligations to determine whether the Consumer Guarantees Act might apply. So these questions cover things such as if the product or service was used inappropriately, damaged by the customer, was known to be faulty beforehand by the customer, was sold after the customer decided to go against the business's advice, or was sold after the customer was unclear about what they wanted.
The Consumer Protection website is a great resource to use to get further information about common problems, and the Disputes Tribunal is another great resource. We recommend exploring these websites, and we've added helpful links to this PowerPoint, which will be sent in the chat and via email to you after this webinar.
So yeah, putting this all together, this is what the resolution journey may look like. It typically involves listening, using resources to understand your options and obligations, negotiating with the other party, and then seeking a determination from the relevant agency, which could be a tribunal or a court.
This final tribunal step is the appropriate step to take if the business is unable to reach agreement on a complaint with a customer. We recommend that consumers and businesses consider this. Often service businesses use it a lot for consumers' unpaid bills, so it's definitely valid to use for both consumers and businesses. It's not necessarily always a bad thing for businesses. The tribunal provides a quick, easy and inexpensive way to resolve disputes. Businesses and consumers can use the tribunal to settle small claims up to $30,000. Anyone can make a claim to the Disputes Tribunal if they think they've not received a fair deal, and for a small fee, the business will have their issue heard and a fair outcome agreed. Because the Consumer Guarantees Act is not regulated and it's a self-enforcing act, the Disputes Tribunal is a way to obtain an outcome for an issue if no resolution can be agreed. It's easy to make a claim on the Disputes Tribunal website, so you can act fast while it's fresh on your mind.
Cool, so now we're going to go through some practical scenarios. The first one is that Jenny has purchased a top. She then changed her mind and now wants a refund from the business. So we can break the scenario down to determine what the business obligations could be here. So following that pattern that we have outlined, the business could first ask a few more questions to determine whether the Consumer Guarantees Act applies here. To better understand whether this is a genuine change of mind and therefore not covered by the Consumer Guarantees Act, the business would need to find out some more information about what has actually prompted this return. So was the top damaged when Jenny received it? Was there any other issues with the top? Did the top not meet Jenny's requirements that she'd specifically asked the business for? Or did Jenny get what she asked for but just has simply changed her mind? We have got a lot of information on the Consumer Protection website that we can refer to help us determine whether a remedy would be required here. Ultimately, a business doesn't have to give a remedy under the Consumer Guarantees Act if the customer got what they asked for but simply changed their mind. This is different from the Fit for Purpose guarantee, which covers when a customer didn't get what they asked for. However, it can be common for some businesses to have a store policy around change of mind. So this is offering more than the Consumer Guarantees Act minimum for customer returns. If it is found that Jenny has simply changed her mind, then the business would likely not have any obligations to Jenny unless they had a store policy. The situation will still require a bit of discussion between the parties to get on the same page, and it can be helpful to refer to our website content to understand each other's rights. If at any point both parties can't agree, the Disputes Tribunal is an option for resolving any disputes under $30,000. Has anyone got any questions about this story?
It's a perfect example because we often get people saying, the customer changed their mind. So really great to understand those clarifying questions. There'll be some tools that we can make sure that retailers are able to use on an ongoing basis. I have got a question about the tribunal though. So firstly, can either party go to the tribunal?
Absolutely.
Yeah.
The business or the consumer can go to the tribunal. Yeah.
And then the next question is, so if the consumer went to the tribunal, does that mean that the business is obligated by the outcome of the tribunal?
Yes, so the disputes tribunal isn't a court itself, but they do have the ability to produce a legally binding court order. So yeah, the outcome of that hearing would determine what actions need to be taken by what party. Yes.
So therefore, for a retailer, if your customer has gone to the tribunal because they're unsatisfied with the resolution that you've offered, you need to continue to be engaged in the process through the tribunal to put forward your side of the case around what you think has occurred and what you think the outcome should be to ensure that the tribunal is able to find out a balanced resolution for both parties.
Absolutely, which is why it's so important for businesses to know their obligations, and the customer is not always going to be right.
Cool. We'll move on to our next scenario.
So scenario 2, Janet bought a laptop from a business that turned out to be faulty. The business initially repaired it, but after 6 months the repair failed and it can't be repaired again. Let's explore this further to see what the business's obligations may be here. So the business can first ask Janet some questions to better understand the situation and to determine whether the CGA applies here. Did Janet damage or misuse the laptop? Did she take an unreasonable amount of time to make the business aware of the issue? Has the laptop already lasted a reasonable length of time? Was the problem caused by something outside of the business's control? Or did Janet ask for the initial repair to be done in a certain way that went against the business's advice? To help answer some of these questions, either the business or the consumer could reach out to a laptop manufacturer to determine whether the initial laptop has already lasted a reasonable length of time in their professional opinion. If it has, it may be found that the CGA has not been breached. The business may also consider having the product inspected. In general, a business may ask the consumer to pay an inspection fee, but they should notify the consumer about these fees ahead of time. If the inspection shows that the product has a genuine fault, then the business should cover this cost under the CGA. But if the inspection shows that the consumer caused the fault, then they may need to pay the fee and the CGA may not apply. Businesses should not make their remedy conditional on the payment of an assessment fee. We can then seek some further information about what the business's obligations could be. We have lots of helpful resources within our toolkit that we can use. The general obligations under the CGA are that a business should provide a remedy for a product or service when one of the guarantees has not been met. One of the guarantees that appears to have not been met in this scenario is acceptable quality, because the laptop does not appear to be fit for its normal purposes, free from defects, or durable. This could mean that Janet may be able to seek a repair, replacement or refund. So where the fault is minor, the business can choose to provide a repair, replacement or a refund. And the Consumer Guarantees Act defines a remedy as a repair, replacement or refund, so store credit cannot be offered for a Consumer Guarantees Act breach. If the fault is serious, then it would be Janet's choice of remedy. Remember, a fault is considered serious if it can't be repaired or if it causes a safety risk. If it is likely that the Consumer Guarantees Act applies, then it is likely to be considered a serious fault in Janet's case, as it can't be repaired. The only viable remedy would likely be a refund of the price that Janet paid for the initial repair, as a replacement or a repair would not be possible in this instance. If it is likely that the Consumer Guarantees Act does not apply, then the business can discuss this with Janet around what their obligations are and why. If Janet does not agree, she or the business may wish to take this matter to the Disputes Tribunal for an official determination. The appropriate tribunal to use in this circumstance would be the Disputes Tribunal. You can read about when the Disputes Tribunal should be used versus other tribunals in the link provided in the notes of this slide. Does anyone have any questions about this story? We have time for a few questions and then we'll move on.
I think there's a question in the Q&A. What's the retailer's responsibility if there's uncertainty that the product was purchased through them, e.g. the customer doesn't have a receipt or a receipt doesn't match the store records?
So I suppose if they don't have any proof and it can't be worked out internally, it might be quite difficult for the disputes tribunal to determine that it was initially purchased from the place. It's tricky when there's no proof.
Would you
Yeah.
go back through bank statements? Would you ask
That could be
the
an
consumer to
option.
go back and show a bank statement that shows a transaction of what would have been a similar value for that product at, whatever date it was done?
Yeah, so under consumer laws, you have to have reasonable proof that you've purchased a product from that business, which doesn't necessarily mean that it can only be a receipt. So if a bank statement is reasonable proof that a customer has bought the product from that business, then that can be used as proof of purchase. And if the business were to say, oh no, we can only accept a receipt, that would be kind of against what the consumer law is saying, because it just has to be reasonable proof. So if the customer didn't have a receipt like this person said, or the receipt doesn't match the store records, if they have reasonable proof in another way, which could be a bank statement or packaging, if it was something that the business only sold that kind of product, then that would count as reasonable proof, and it would probably give the customer a case even if they didn't have a receipt. Yeah.
Okay, cool. And then I had a question about, you said that products can be inspected. How do you determine who would do an inspection?
I would say a industry professional, because once again, if it does go to the disputes tribunal, it's good to have some evidence to show that a professional has thought that the laptop did not last a reasonable length of time. But often perhaps the manufacturer could be an option, or even just any repair store. Another option is to get a few different opinions to see what the average time is in their opinion.
Yeah, because I think often if you're thinking about electrical appliances, often the stores selling the goods may well be also servicing those goods. So they, it's a conflict in terms of them being able to provide that same advice themselves. So it'd be interesting to see how, and with some goods, how you could get an independent inspection. But, good to know anyway.
Cool. No more questions at this stage?
Nothing further at this stage.
Cool. All right. We'll go to our next scenario. So Brian has bought a phone online from a business that has provided delivery of the phone via a courier company, but the phone has never arrived. We can now unpack this further to determine what the obligations could be. So for this situation, the business will need to ask some clarifying questions, mainly to the courier service. A good clarifying question that the business may wish to ask the courier is whether the courier has proof that they delivered the phone. This proof may be a photo of the parcel at the address or a signature from the customer. So based on the information found on the website, if a business sells products and organises delivery, they must also make sure that the delivery arrives at the agreed time and in acceptable condition. If this guarantee has not been met, the customers can get a remedy from the business. So as the courier service was purchased by the business, not by Brian, the business would be responsible for delivery under the Consumer Guarantees Act. So this would involve following up with the courier company directly to get the issue resolved and providing a remedy to Brian in the meantime. It wouldn't be up to Brian to sort it out with the courier directly. In terms of business guidance, the Contract and Commercial Law Act would likely provide a bit more protection for a business in this type of situation compared to the Consumer Guarantees Act, so the business may wish to make a claim against the courier company under this act. As always, the business and the consumer should work together to negotiate a resolution, which would be a replacement or a refund in this case. If the business can promptly replace or refund the goods, then it would be a minor problem and the business has the choice of remedy. If the goods don't arrive and the business fails to replace or refund the goods quickly or at all, then it would likely be considered a major problem and Brian may choose the remedy. If the business and Brian cannot agree, then they can seek a determination from the relevant tribunal, which would be the disputes tribunal in this case. Does anyone have any questions about this scenario?
I've got two questions about that, or points of clarification really, I guess. So if the goods were delivered, but the customer never received it, e.g. it was stolen, does the supplier have the responsibility? So would the retailer have the responsibility? Is that the courier or is it the consumer?
I
So the
guess it would
courier's got
come
evidence
back.
that's been delivered.
Yeah, so if they've got that evidence that it's been delivered and there was no kind of specific instruction by the consumer of where to leave it or anything like that. Once the courier has delivered the item, that's kind of the job done in that sense. So it is unfortunate, but there probably wouldn't be any redress for that if there's that proof that it was delivered.
Yeah, like we talked about in the clarifying questions before about proof, that's kind of the key here. Because if something hasn't arrived, but there's no proof, then that would mean it would be up to the business to remedy the issue. But if something was delivered and there was proof it was delivered, and like this person said, it was just that it was stolen, then the business has done what they need to do. And it's just one of those unfortunate things that had come at the cost of the consumer in that instance. But yeah.
So from a retail perspective, when we think about that, it's making sure that you're selecting a really quality freight company to do your deliveries, that you understand what evidence they're going to provide for you on pickup and drop off, so that you will have that evidence if something goes wrong at the consumer's end. So make sure that you're really following through with your couriers to ensure how that works. And if you are organising the couriers, then I would always, for your own protection, think about the tracked method versus an untracked method, so you can see where that item is all the way through, and also the consumer can see that as well. And thinking about how you would include those costs at point of sale on your site, whether you have them separate or whether they're added in. We can talk about that later.
Yeah, that's really great guidance.
Then there's a question I've got about second-hand goods. And so the question's really about if you're a business that sells second-hand goods, like a charity store or a second-hand fashion store or something like that, how does the Act apply in those circumstances? How do those charity businesses make sure that they're adhering to the Act and that we understand, when something's not new, when it's being purchased, how does that work its way through?
Yeah, that's a really great question. When it comes to secondhand goods, if they're being sold by a business, then the CGA applies. The CGA applies to any household or personal goods sold by a business. So they would apply if it was sold by a business. But when it comes to the guarantees such as acceptable quality, the fact that it is secondhand would be taken into account for, whether it's lasted a reasonable time. That will all depend on the fact that it's secondhand. So yeah, it would be covered by the CGA if it was sold by a business, definitely. But yeah, it's all about the nature and type of the product, and the type of product that kind of defines how those acceptable quality kind of guarantees come into play. So yeah.
And so the price of the value would have an interrelationship as well. So if something was priced at, $20 versus $120, you would expect to have a different level of quality and last a different length of time. Would that be fair to say?
Yes, I would say so. Would you say so, Kate?
Yeah, I agree with that, because I think if you think about secondhand goods, you can't really expect them to be the same as new products. And yes, we can take into consideration things about what you were told about them, general wear and tear, and how much was paid for the product.
I've got another question here. If a customer is returning a faulty product via a courier, who should pay for the courier costs, the customer or the retailer? It's a great question.
If it's found that the CGA has been breached, then the business should refund the consumer for the postage price. But if they're returning it for a change of mind, or it was found the CGA wasn't breached, then the consumer should pay the cost.
So if you're going to repair a faulty product, then you would be responsible for the freight coming back into you. You'd have to organise the courier to come back. Is that what you're recommending?
Generally, yeah. If the CGA, if you're returning it for reasons because the CGA has been breached, then generally, yeah. So we also have a useful tool on our website, which I'm going to screen share now. So we have this useful tool on our website that can provide an overview of what rights people may have under the CGA. So if you go to our website, you can either click check your rights, that one here, or you can click this one. It takes you to a tool which we call the Consumer Rights Finder. And the way it works, you click which one the problem's about. So if it's related to a product or a service or a car or flights, you click on the right one that's appropriate for you. And the way it works is you answer the questions as they relate to your specific scenario, and it can tell you a little bit about the relevant consumer laws and that could apply to your situation and the potential next steps you could take. So that's a really helpful tool. And something else that you should know about on a website is from the homepage. Some of the other web pages that we reference in the slides of this webinar were the business guidance pages. So you can see on the top level nav here, there's a tab that says business guidance, and these pages under business guidance are really helpful, and we really recommend you familiarising yourself with the information under these.
It's amazing, thank you. Got a further question. Is there a time frame for faulty returns, e.g. somebody purchases a bag and then they take 10 months or a year to return it? Is that, how do you determine what's reasonable?
Yeah, it's best if they can return it as soon as they become aware of the issue. But in terms of defining a reasonable length of time, I'm not too sure if we've got anything more in depth than that, because it would be, I guess, a case-by-case basis, depending on how difficult it is to return and the reason for why they maybe have waited that long. But generally, I would say better to do it ASAP, get it all sorted.
Yeah, in this scenario where they're saying that, you took a year to bring it back, that probably would be an unreasonable length of time to return a product. But just depends on the product and the nature of the product and how long it would take to discover a fault in it and stuff like that. So
because from a retailer's perspective, that means that the liability for that product has quite a long extension if someone doesn't bring it back for quite a long period of time. So
yeah.
Really fantastic to have Cate and Kadie with us today. And look, here's some key things that I found. It's really good to have a key understanding of the situation when a consumer comes into your store and they've got questions for you about a product, about it being faulty or not fit for purpose. So really understand what the situation is. You need to equip yourself with tools if anything goes wrong. So make sure that your policies and your staff really fully understand your obligations as a retailer under the Consumer Guarantees Act. Sometimes legal escalation to the tribunal is inevitable, and sometimes it can actually be helpful to get that solution where you can't get it through negotiation yourselves. Key 3 things are repair, refund or replacement. Always try and resolve yourself if you can, and if not, go to the tribunal. There's lots of tools and information on the Consumer Protection website. Check it out and know what your rights are and your responsibilities. We'll have this webinar up so you can come back and refer to it, or you can jump onto the advice line, ask Yev for some answers to some questions, and we'll be able to get solutions for you. Ensure that all the work that you do is compliant with the Act, and you know when it applies and when it doesn't apply. Making sure that your products are fit for purpose, they're safe, they're durable. Those are some of those key things, really understanding to make sure that you protect yourself. And when you've got a consumer that comes into your store and they're concerned about their product and they want to return it under the Consumer Guarantees Act, don't forget to ask those clarifying questions that Cate and Kadie talked about. So, clarifying questions from the consumer around to better understand what's happened and what's occurred. You can also get the product inspected. That was the other thing I learned today, was just your ability to get that product inspected. But we probably still have 3 minutes for any additional questions. And if you guys have got any final wrap-up comments?
I suppose people, if something does come to you, you have a question after this webinar, just reflecting on it, you can always ask that question in the survey. So don't be shy to, send us your questions and we'll help as best as we can.
Fantastic. Look, thank you so much for joining us today, Cate and Kadie. It was really great, and we really appreciate MB for sharing this information and supporting the retail sector in New Zealand. And because we've been able to record this webinar, it'll be a resource for our members on an ongoing basis. So thanks very much. I hope all the retailers have found this session informative and useful. As we mentioned, a recording of this event will be sent out along with the PowerPoint presentation and a quick 5-question survey to follow up, so that we can get all your feedback and make sure that we can continue to provide you good, strong advice and answer all your questions. So till next time, ka kite anō, bye for now. Kia ora.
Kia ora, thanks everyone.